Hi, and thank you everybody for joining us for today's webinar on using the voucher benefit to help your clients and your firm. Before we get to introductions, I'd like to make a few housekeeping announcements. This webinar is pending MCLE credit. In order to qualify for the credit, you'll need to stay logged in for the entire session. Hopefully, we'll have enough time to answer many of your questions. If you do have questions, please click on the Q&A bubble at the bottom of your screen and type them there. My name is John Blake, and I'm the Director of Sales here at Gemini Legal. We are always striving to bring new and valuable content to the applicant workers' compensation community throughout California. You'll be able to find a recording of this and prior webinars on our Gemini Legal YouTube channel. You'll also find attorney interviews and other helpful information there. I'm thrilled to be joined on this panel today by three fantastic professionals that will each share some unique ideas around the use of the voucher benefit. I'll let each of them introduce themselves, starting with Armin. Go ahead.
Hi, good afternoon, everyone. My name is Armin Kechikian. I am with Kechikian Law Group, APC, and I am practicing workers' comp for 11 years.
Wonderful. Thanks, Armin. Rando?
Sure. Yeah. Great to be here. My name is Rando Rodriguez. I'm a lawyer in Sacramento at Easton and Tambernini, and I handle workers' compensation cases. Been a lawyer for about 20 years, and for the past 6 years, I've been doing workers' comp, and I really enjoy it. Before that, I did just regular third-party car accident type of cases, slip and falls, things like that. But I'm enjoying the workers' comp.
Great. Thanks, Rando. And our third panelist is Nadia. Go ahead.
Good afternoon. My name is Nadia Dow. I am Gemini's Vocational Rehabilitation Counselor and also the Division Manager for Vouchers for Sales.
All right. Wonderful. Well, with that, I'm just going to go ahead and get right into it. So, Armin, you have some unique things to talk about. And the first thing that we talked about was how to get multiple vouchers for the same client. And you're one of the only attorneys that I know of that's been able to figure out how to do that. So you want to explain a little bit about how the labor code works post 2013 and how you go about getting multiple vouchers.
Okay. So basically, other than the fact that there are multiple case laws supporting injured worker entitlement for multiple vouchers for multiple dates of injuries, the most important reference that needs to be made is on the Labor Code section 4658.7, which talks about entitlement of voucher for dates of injury after January 1st, 2013, which will be my main focus. Basically, according to that code section, it basically says if the injury is causing permanent partial disability, from that point, obviously, employer has 60 days to offer a modified alternative or regular work. And if they don't, then that entitles applicants entitlement for multiple vouchers. So obviously, in a perfect world, we applicants attorneys like to have one date of injury and that all the complaints are related to one date of injury so that there is no decrease of permanent disability. Unfortunately, most of the time, that's not the case. That's why I kind of try to figure out, okay, if there is a decrease on permanent disability, can we at least use multiple dates of injuries to the benefit of our clients? And again, the benefit we're going to get is going to be the multiple supplemental job displacement vouchers. And the first case that I litigated on that subject matter is Sandra Morales versus Marriott Hotel. So basically, we have an orthopedic AME in that case. I believe it was Dr. Philip Cantor who did Benson apportionment between specific and cumulative trauma. And at that time, the trial judge was Judge Pollack and in Van Nuys Sports. So according to Judge Pollack, when he denied at the time of trial, he issued a decision saying that multiple voucher, that my client is not entitled to multiple vouchers because temporary disability was running concurrently for both dates of injury. So in other words, he used a case law by analogy. And then I ended up filing a petition for reconsideration, and Office of Commissioners agreed with me that you're basically using a case law by analogy if there is no specific code section, regulation, or a case law addressing that issue. And on this case, specifically, Office of Commissioners indicated that Labor Code section 4658.7 is very clear. It says if an injury causing permanent partial disability, and since there is a multiple dates of injuries, there is that's sufficient, and there is at least 1% permanent disability for each date of injury, that's sufficient for you to get multiple vouchers, regardless whether the temporary disability runs concurrently, regardless whether there is an overlapping body parts, and sometimes you might feel an argument that the employer needs to offer only one modified work alternative, etc., to the employee, not only one offer to come back to work, regular modified alternative. None of these arguments relevant. Even if your client like quit his job or terminated for good cause, etc., it's absolutely irrelevant for you to be able to get multiple vouchers. And one other material that John provided was my case, Stephen McRae. We got like 3 dates of injuries. One was for the dental, the other 2 were orthopedic. Each caused permanent partial disability, and Judge Feddersen agreed and provided literally 3 vouchers per date of injury. Unfortunately, you can only get one $5,000 cash from Return to Work Fund, not multiple. But again, you can even combine all 3 vouchers to have a better opportunity to retrain yourself using obviously the services of vocational counselors.
And that's what I wanted to ask Nadia about. So they get 3 separate vouchers. How are they able to use them? How are they able to combine them? What are they able to do with those 3 separate vouchers?
So again, it depends on the individual and what they want to accomplish. There's always prerequisite coursework for something that they may want to do. For example, becoming a medical assistant. Maybe they want to do medical billing in conjunction with that. You can even, if they're looking at a particular program that is a bit more expensive, you can combine the costs of the vouchers and reach out to the adjuster and have that allocated for them to pay the whole tuition rather than having financial aid. So it just depends on the individual, what they want to accomplish. Sometimes there's need for training in a couple of different areas. Maybe they want to learn how to really be strong with the computer applications, then do the medical billing, then medical assistant. So again, the multiple vouchers is great, and it allows them to get a whole picture for what they want to accomplish in steps.
That's great. So Armin, the other thing that we talked about is sometimes instead of multiple vouchers, you can use it as a negotiation tactic. You want to talk a little bit about that?
Yes, absolutely. Even though after date of injury, January 1st, 2013, obviously they are stating that you cannot settle a voucher. And I understand there is a case law which basically says if a case is resolved on a fully denied status, then some defense attorneys would like to get the finding from a judge that applicant is not entitled for supplemental job displacement voucher. But in my practice, I think what basically happened, let's say if you get multiple vouchers and claim adjuster doesn't want to give more than 1 voucher to the applicant, sometimes you could use it as a settlement negotiation technique. For example, what I did and successfully on many of my cases, let's say if each supplemental job voucher is $6,000 worth of benefit, I have cases where I got extra $5,000 on a CNR and agreed to 1 voucher instead of the 2 vouchers. So and basically on that, it doesn't say that applicant is not entitled to multiple vouchers. On the CNR language, it says applicant waives her right to litigate her entitlement for a second voucher, etc., or that applicant will not pursue the second supplemental job displacement voucher.
And I just want to add, every single voucher will allow the individual to get the 1,000 for supplies and the 500 for miscellaneous. So you can do it that way as well, going back to what you were asking about the multiple vouchers and the monies that are allocated for equipment and miscellaneous.
So we have a couple of questions that came in that I think are directly related to this. So it says, you said EE who gets multiple vouchers does not get multiple 5K from the return to work fund. Why not? I have cases where a client has, two cases, 2 DOIs, and we did get a global CNR with 2 vouchers issues, 1 on each DOI claim number, and my client got $10,000, 2 separate $5,000 from the RTW fund when she submitted the 2 vouchers. Is that because those were 2 separate cases? You're talking about RTW on, you can only get 1 per case. It's not 1 per client. So if they have 2 separate cases, they could potentially get 2 RTWs, right?
Potentially, yes. If you're asking me, I can tell you that we go ahead and process for RTW. It doesn't necessarily mean that they're gonna get the RTW. It depends when the date of injury is and when the RTW catches up with that, right? Because this is a state fund, so you can never decide for them what's gonna transpire, but it can be done.
Yeah.
So this
Yeah.
individual, correct.
Okay, good deal. To kind of change up a little bit, so you did mention that the language on the CNR is pretty important. Are there things that an attorney needs to be careful of with the language on the CNR, Armin?
I guess the language which I never have any problem with is, again, we cannot say the defendants, we wouldn't, I wouldn't put a language which says applicants decides to settle the second voucher, because technically for dates of injuries after January 1st, 2013, you cannot settle a supplemental job displacement voucher. I think to be at the safer side, it will be much better if it says applicant will not pursue the second supplemental job displacement voucher, which was part of the settlement agreement, or yeah, I think that language will give you a full protection.
Okay, good deal. And are there some cases where you could possibly get attorney's fees?
My position always been the same. As most applicants, attorneys know, a lot of cases being settled on a different stage of the case. For example, sometimes you get the diagnostic studies, etc. You have a kind of good understanding what the value of the case is. You might settle the case when there is no final PNS report, or you settle the case on a fully denied status, etc. What I always do, in other words, number one, which saving my time, and I don't want to go through all the problem and loopholes, every single CNR that I sign, I put the language which says defense to provide applicant with supplemental job displacement voucher within 30 days of receipt of order approving CNR. If they don't provide a voucher in that 30 days, to me, that's basically non-compliance of the CNR terms and order approving CNR. And if you have to enforce the terms of CNR, you should be able to be entitled to attorney fees, like costs and penalties. And usually what I do is, if they don't provide, automatically I am asking for 10% penalty on the voucher amount, in the amount of $600 payable to my client, and 15% attorney fees from that 6,000 voucher amount in the amount of $900. And sometimes if it's excessively late, then you can go as far as 25%, which is $1,500 payable to the applicant and $1,500 payable to his or her attorney. And if they providing a defective voucher for me is if one of the following applies. Expiration date is incorrect. 5 years from date of injury, 2 years from the date of issuance, whichever is late, or if proof of service is not filled out and signed, which means the voucher is not usable. To me, providing defective voucher is as bad as not providing any voucher.
Okay, good deal. So I'm gonna switch gears a little bit. So Rando, when you and I talked, we talked a little bit different about how you use the vouchers on larger cases, how you use the voucher benefit to help you with larger cases. And we talked a little bit about the LaBouffe case and how that's relevant in that situation. So do you want to talk a little bit about that?
Yeah, sure. Thanks, John. Yeah, you know, with larger cases, usually the issue I have is that my client's not able to return to work. And, you know, a lot of my clients really want to return to work and they go through some type of retraining to try to get back to work, whether it's through the voucher or through something else, but they're just not able to. They're not, for whatever reason, you know, having to do with the injury. Maybe they can't concentrate because they have headaches or they have pain. And they're you know, not able to complete any type of schooling in connection with the voucher or things like that. And yeah, we talked about the LaBouffe case, which I, you know, find still relevant, even though it's, you know, 40 years, coming up on 40 years old, because it's a 1983 case, but it's a California Supreme Court case. And you know, the relevance to me is that you can reopen this issue of permanent disability if your client's not able to return to work. And, you know, the technical language is if they're not amenable to rehabilitation to find suitable, meaningful work. And so, you know, a lot of my clients that have gone through the QME process and we, you know, the QME finds that there's a certain percentage of disability, whether it's, you know, 20% or 30%. Sometimes we'll agree on that as long as there's still time to reopen. We'll stipulate to the 20% or 30% permanent disability. But I'll follow up with my client, you know, 6 months later or a year later to find out if they actually have been retrained, you know, assuming that they weren't offered a return to work, which very few of my clients are offered a return to work, you know, through the employer. So if they haven't found, you know, work 6 months or a year later, and they've gone through a retraining process and done everything that they can, then I'll reopen the case and I'll hire a vocational expert and we'll explore all of the reasons why they haven't been able to return to work and just make it a bigger case at that point.
Sure. And so in those cases, and so which cases is that strategy been most effective on? Is it cases that you're somewhere on a lower percentage to start and then you're trying to get them to an upper percentage, obviously?
Right. Yeah, that's a good question, John. Yeah, I mean, some of my cases, it's obvious that I'm, you know, going for 100% permanent disability because the guy fell off of a roof and you know, he's in a wheelchair now. Obviously, those cases I don't need to take like some kind of alternate path because it's obvious that person's never going to work again. Yeah, so on the cases that are smaller than that, and frankly, on cases when I'm not completely convinced that my client can't return to work, you know, we'll go through that process of stipulating to the disability. And then, you know, when I follow up 6 months later or a year later, and they tell me everything that they've been doing to try to get back to work, you know, as long as it's you know, I find it credible and I want to proceed. Yeah, it's those types of cases. So I would say it's the 20% to 50% permanent disability type of cases when it's not glaring that it's 100% permanent disability case that can be, you know, sought.
Yep. And Armin, you actually had a question for him, right?
Yes, I do. Basically, my question is because I utilize vocational experts in the past, and as you know, like proving 100% disability using vocational expert is not that easy, because if there is any non-industrial condition which contributes to applicants' ability to compete in open labor market, then it will be very impossible to get 100% on an industrial basis unless we prove up that even in the absence of non-industrial factors, that person is unable to return back to work as a result of industrial injuries.
Yeah, right. And yeah, there are a couple of vocational experts that I use, and they're, they have a lot of years of experience, and they know, what to put in their report. So usually I'll find a section in the report from my vocational expert that talks about Montana factors or impermissible factors when you're trying to prove a case is 100% permanent disability because of the injury and not because of something else, like the fact that he couldn't speak English or something like that. So that'll be addressed in the report. But inevitably it comes up in the defense experts report. There'll be some type of accusation that what we're really doing here is trying to look at impermissible factors. And so occasionally I have my own expert write a rebuttal report if I think it's needed, before we submit it to the judge.
Okay.
Yep, good deal. Okay, then is there anything else that you wanted to add onto that, Rando, before I move on?
No, that's it for now.
All right, good deal. So Nadia, I wanted to go to you. A couple of questions for you as a voucher counselor. What is it that a law firm should look for in a counselor or a counseling service? What should they watch out for? Might even be a better
well,
question.
I mean, there's several things. First of all, you want to make sure that the counselor is on the DIR, right? That's a great way to keep it kosher. That the counselor or the counseling firm works with every post-secondary accredited school. Doesn't have specific schools that they only work with, right? Because the whole idea is that you're using every single school that's approved by the state to identify what's important for the injured worker based on, demographics, right? You don't want to send a client 50 miles away when there's one that's 10 miles away, if they're all post-secondary accredited. To make sure that the counselor or counseling firm, it's very important, not necessarily particularly using a school or an individual that is not going to be there for the client, right? Because the counselor's obligation is to make sure that they're with the client throughout the duration and the whole process, and making sure that they receive all their entitled benefits, that they get everything that's allocated for them. And so those are the most important things I would say are important in utilizing a specific counselor or counseling firm, making sure that the client, gets their RTW process right away, making sure that the client gets follow-up and attention.
Okay, good deal. And then why would someone want to use a counselor instead of just doing it self-service and, taking advantage of all the money themselves?
Well, there's many times that the client thinks that they're going to be able to do it. They choose a school, the school closes down. What happens to them then? If it closes down for fraudulence or a fire, or they don't have funding, the counselor is the one that's able to protect them, ask for a second voucher if there's an issue and they've utilized the post-secondary accredited. It's a daunting process. It's like asking, why wouldn't you use an attorney? There could be a lot of mishaps that transpire without using a counselor. And many times they think that they can do it, and at the end, then they're stuck with something, and then they call the attorney and say, hey, I don't know how to do this. And the attorney will say to them, well, why didn't you use a counselor? It's for that safety net, because there's so many different things that can transpire, especially with the adjuster, the insurance company, or the insurance company changing. And so they're waiting for their funds. So having a counselor on a file assures them the protection that they're entitled to throughout the whole process.
Okay, that brings me to a great point. There's a question here that goes along with it. Can you break down that $6,000?
Sure.
What is it used for? How much goes to a counselor, et cetera? What's
Sure.
it? based on?
Yeah, I get that asked all the time. What's your fee? You know, well, a counselor doesn't have a fee. The way that the voucher works is that obviously, if we're talking about post 2013, you've got the $5,000 from the RTW benefit that comes from the state. That's completely separate. The second benefit is a $6,000 voucher. Underneath the $6,000, there's a code for training. There's a code for rehab services, maximum $600. 10% of the voucher. We are talking about post 2013, obviously. That is it. There can't be any other amounts that are allocated to the counselor. Then the $1,000 supplies and the $500 miscellaneous. That's it. So when you're dealing with a client, we always tell them, listen, you're not paying for anything. Everything is allocated underneath this voucher for your benefit, for your purposes. I also I saw on the chat the question about, can you get the $5,000 from the RTW without a voucher? Well, you know, the proof of service is part of the voucher. That's what we need to be able to get the RTW. So without it, no.
Got it. And then how has what voucher counselors do changed now with this whole remote work idea?
It's been amazing. It's been amazing. You know, if you think about it, 10 years ago, what remote work was, you know, telemarketing, you know, part-time jobs. And now with schools really focusing on doing online programs, identifying new certifications that can be done online, the job force, the workforce that is now allowing people to have full positions from home. And it's been really a blessing in disguise, if I can say that, because the remote has been really received very well. All the post-secondary accredited schools have now added curriculums and added programs that are for remote training, and the jobs are out there in full blast. I mean, like I said, 10 years ago, you didn't have that luxury. Now you do. So remote has been really really good for the injured worker as well as the employer.
Good deal. And so I had a couple of questions that came up here. So does the potential salary after VOC training have any bearing on the cost of the RTW program?
So you mean the earning capacity or what the person was earning at the time of injury? No. The whole idea is when you're working with the individual, it depends on the individual, what they want to accomplish. Do they want to stay in the same industry? If they're staying in the same industry, obviously they've got that experience under their belt, so they'll be able to get you know, training rather easily that will support and be able to mobilize them from this position to a supervisor or management position. If they're starting from scratch in a new industry, you're looking at the entry-level salaries that are allocated. But as far as what the earning potential was, no, it doesn't have anything to do with the voucher.
Good deal. And a question here, if the client is not PNS'd but wants to settle, how can the attorney still get a voucher for the client? Any tricks or advice?
I can answer that question because I did that. To keep it like a straight and simple, here is the thing. When you CNR the case, you cannot settle the voucher. There was a case where a defense attorney wanted to CNR the case on a fully denied status. He couldn't get the authority to provide the voucher to my client, and my client really badly wanted to get the voucher, and we didn't get the PTP PNS report. What I told the defense, I took actions on that, I say, look, we'll CNR the case, I'm gonna set the PTP deposition, I'm gonna ask the primary treating physician to provide me conditional MMI report based on the last physical examination findings, because as we know, you can get whole person impairment based on loss of range of motion, and then I will file a DOR and litigate that issue. Obviously now defense attorney has to reimburse me $58.11 cost for doctor depot. Now, as you know, it's $910 plus court reporter fee. and litigate all those issues, DOR, MSC trial. And after I set the PTP cross-ex, he sent me the voucher. Or you can do the same thing, asking a supplemental report from a PTP. In other words, yes, we have to advocate for our clients. They might say, oh, you know, bad faith. I don't see any bad faith on my end. I feel like, yes, you kind of creating litigation expenses, taking these extra steps, but I promise you, your clients will appreciate that.
Okay.
So, yeah. And by the way, the only other thing I want to include that Mr. Rodriguez covered regarding 100%, I believe even if defense attorney's vocational expert report was more persuasive than yours and says 100% disabled due to non-industrial factors in addition to industrial factors, then you can convert it into a subsequent injury fund case and go after SIF for 100%, assuming you have 35%, obviously, permanent disability as a result of an industrial injury.
Okay, good deal. And a couple more questions that came up that I think are more focused towards what Rando was talking about. Looking towards the future for a potential 100% PD, how useful are RU91 and or description of employee job duties?
Well, I mean, most of my clients that, have a case where I'm, hiring a vocational expert and going for a 100% permanent disability, honestly, the prior job duties or the job duties at the time of injury aren't exactly relevant because, the employer has already rejected the injured worker in terms of returning them to work. And, and now, the person has gone through vocational, training, used the voucher, and they're still not able to find work. And so, at that point, it's my argument that they're not able to be retrained for any work, so not just what they were doing at the time of injury. And I certainly have clients across the board. I have a client that's a doctor, a lawyer, and lots of farm workers and warehouse workers as well. So yeah, honestly, to me, the subject of job description or work activities, that comes up during the underlying case, usually when it's not a 100% case and we're, fighting over the permanent disability rating.
And how can you get a vocational counselor assigned to complete RU91 description of employee job duties?
Yeah, usually, honestly, when I engage a vocational counselor, I'll introduce my client to the vocational counselor, and usually they, develop things from there on their own. I've never been approached by a client or a vocational counselor saying that they needed additional help getting, additional documentation or information. That's why I usually talk about the 6 months or a year down the road. I'll talk to the client. They've already tried vocational counseling and used the voucher. So yeah, frankly, an RU91 is not something I'm usually asked about.
Okay. And Nadia, I had a question for you. What I know you said you want to look for somebody who works with every post-secondary school, but what type of schools should the client's expectation be? I mean, what should the client's expectation be of what type of schools they can use when they get the voucher? I mean, what types of things are they going to be able to be retrained on?
So ultimately, that depends on their restrictions. So when you're doing the initial and you're taking into account what their interests are, you're also taking into account what their restrictions are, because obviously those restrictions are going to permeate and allow or not allow the individual to be able to go to that particular training, right? So if they're saying that they've got bilateral carpal tunnel and they want to become a secretary, as much as voice activation can help, that's not going to be necessarily the way to go. The schools, there's so many interesting programs. There's medical assistant, there's phlebotomy, there's ET, there's real estate, there's drone for journalism, there's higher educations. I do want to mention also, going back to what you were saying when I was asked about the $600, remember also that most of the training programs already are fixed amount. And they've already taken that into account so that the money is there for the counselor. So it doesn't interfere with the tuition of the individual. It's not being taken away. It's added onto the 6,000. That's what was taken into consideration to make sure that the client had the counselor for the support, as well as the training, as well as their, supplies and computer reimbursements and whatnot. So going back to the types of programs, it runs the whole gamut. It can be in the medical field, it can be in the transportation field, it can be in the trucking field. There's so many new exciting positions. There's horse therapy. There's, believe it or not, there's art therapy. There are so many new programs. And again, remote has been able to add those curriculums. So it can be as creative or non-creative as the individual wants. It really starts with them.
So like there is a question here. Is there something for home inspection? Do you know?
There is.
Okay.
There's multiple different programs that are for home inspectors. Again, it's not something that I would tell the attorney, hey, attorney, yeah, go ahead, tell the client that they can do this, because again, once we receive it, we're paying attention to the medical restrictions. The adjuster and the insurance company are not going to comply if it doesn't interfere, if it does interfere with the medical restrictions. If it doesn't, then we can consider whatever it is that they're interested in: home inspection, home decorations, commercial licenses, residential licenses. There's several, and there's over 800 that are listed on the DIR. The other thing I also want to mention is, I get asked a lot, can a person that's out of state be able to participate in the voucher program? Yes. We're looking at online that are originated from California, a California-based school, which allows this displaced individual that now has had to relocate to Texas or to Arizona because they just don't have the money or the affordability in California. So as long as the program originates from California, they are able to participate on an online program.
So I've had a question from a number of attorneys that kind of questions the whether most people are actually using the voucher or not. Now, without going into percentages or what you've seen as a company, are most people using the voucher, or are most people not using the voucher?
Most people are using the voucher. That is why our topic today is multiple vouchers. They're using them to the point that they can actually combine incomes and be able to do full, part-time jobs. So they are using the voucher. They're using it not necessarily in the traditional way. As the attorney is explaining it to the client, it could be day-to-day living. It could be something as simple as, look, you're going to need a computer and you've never learned how to use this. What about teleconferences? Imagine on top of everything else, or an earthquake. How are you going to get your medications? It's day-to-day living, as well as training, as well as hobbies, photography online. It just runs the gamut. It doesn't necessarily mean that at the time that they use the voucher, they must return to a job. It means that the voucher has enabled them to be able to utilize it because they qualify for that benefit, period.
And the next question, I'm sure the answer starts with "it depends," but it's my favorite attorney answer. It's whatever I ask, it starts with "depends." So realistically, how often are the available vocational programs, retraining programs, considering the value of the voucher program, going to be successful in obtaining substantive employment?
Who are you asking that to? Are you asking it to the attorneys or to the counselor on the
I
panel?
think to you to start. I mean, if the attorneys want to join in, but I think you have most experience in that area.
Listen, this past fiscal year, the amount of graduations we've gone to and the amount of correspondence that we've received from clients saying thank you so much, and that they've been retrained in a position where they're working from home or being able to do something that they never thought they could do, is definitely high. So it does depend. I will start. It depends on the individual and what they want to accomplish. At the end of the day, you can lead a horse to water.
Yeah.
Are there any?
Yeah, John,
Yeah, go ahead.
yeah, I'd like to add that, I appreciate what Nadia said. For me, there's really no way of knowing exactly, how many success stories there are out there. I tend to get the ones that are not successful that will need to come back and will reopen their case. But by definition, then there has to be all of these other cases that the client has been retrained and moved on with their life, which is always my goal for my client. I always want my client to be able to re-engage with employment and move on with the life that they had.
Yep.
And if you would allow me, John, just want to add a couple of important things on this voucher subject matter. Is number one, obviously, the way I look at the voucher is providing people opportunity, whether they're going to use it or not. At least we should give them an opportunity to be retrained and be more competitive in open labor market. The other important thing I want to very briefly touch is when is the time that triggers employer's obligation to provide applicant with supplemental job displacement voucher, which can also trigger to ask for costs, attorney fees, and penalties. My position is the following. Because the rules for voucher were changed after date of injury, January 1st, 2013, once you have compensable MMI report from a doctor for the direct injury, which is not compensable consequence, and they don't offer any modified alternative or regular work in 60 days, from that point, they have obligation to give the voucher. You don't have to have an MMI report from a psych AME, internal, dental, ortho, etc. If there is like a direct psych injury, but you don't have an ortho MMI report, that's good enough. So, and from that point, while your case in chief is pending, all you need to do is kind of create a universal, like a letter regarding voucher production that applicant was MMI'd for this direct date of injury. There is a permanent partial disability. Reach out to employer. If they don't provide regular modified alternative work in 60 days, we'll file a DOR to enforce voucher. We'll seek attorney fees, costs, and penalties for enforcing it.
And I would also like to add, because I am seeing the chat, it is, I believe, the community's obligation to offer an injured worker another opportunity to exist, especially when you're dealing with individuals who've been at a job for 20 years. And so it's a detriment whenever you don't offer the voucher, whenever you don't fight for the voucher, because as you know, post 2013, you can't settle it out. And so when you're trying to use it as a negotiation tactic, remember, they're going to get the $5,000 from the state. So if you, attorney, are only getting $45,000, it's just a win-win, because add the $5,000 from the RTW, that alone gives the amp up for this injured worker to have extra funds. Not only that, but then you've got the $6,000, which enables them to consider something that they may have not been able to consider before, and also be able to utilize the funds available underneath that for the computer, for the equipment, for the miscellaneous. So in every case, it's just a no-brainer. Give the CNR the opportunity. Don't assume that they'll automatically get it. Everybody knows that you can't just assume. It's always best to write that they're entitled to the SJDB benefit in the CNR. And then this way, you're giving the opportunity for the client to move forward in their lives. So there's no way that the voucher is not a benefit.
And speaking of moving forward in their life, there's somebody who said, is any self-employment possibilities to be generated from the voucher? I'm sure there is.
Absolutely. I mean, that's one of the things I talk about when I'm asking about this lifestyle. You know, are you wanting to go back to work for somebody? Do you want to work for yourself? What are you interested in doing? You take an individual that I just recently had that was a carpenter, and he can no longer do that, but he has all these connections in the industry. What are you lacking? Well, I'd love to be able to do estimations and bids, or do billing and so forth, or media presentations so that they know how to reach me, so that I can then have somebody on my team be able to do the physical aspect, but I can oversee it. There you go. It's proof in the pudding. There are several self-employment opportunities.
Great.
The opportunities are boundless.
There was a question here. I don't know how it's going to be answered. So if we want to go back to some prior cases that closed out a while back, and if those people need help with the voucher and or RTW state credit, how can we refer them to you? Is there a preferred email address, et cetera? So
Thank you so much. That's important. First of all, remember, the RTW benefit is only good for a year as of the time that voucher is allocated to the individual, only for a year. It is very different from the benefit that Armin was talking about for the voucher that is post 2013, 2 years as of PNS or 5 years as of date of injury. So one is very time sensitive and is only good for that year. So if it's been past a year, I would not mention it because it's nil and void. It's not something that we're going to be able to fight with the state. If the voucher is still in play, I will make sure that John sends you my information, but the voucher counselor email, as well as the team for the case specialists, and I can put that on the chat as well.
yeah, with all of your permission, I'll send a follow-up email with all of your contact information, if that's okay with all the three of you.
Sure.
Absolutely. Thank you.
Because I'm sure questions come up afterwards. Be nice to have your information. Or if somebody had
I
something.
have no problem.
Good deal. Anything else that you guys would like to add at this point?
I think the only other thing I would like to add regarding some benefit when people are getting the vouchers while the case in chief is still pending is the following. Always my philosophy being, in order for applicants' attorneys to avoid undersettle the case, because sometimes your client might be like a financially broke and consider offer that you don't think is reasonable and fair. So let's say if they're using a voucher while the case in chief is pending, and based on the new skills they're getting a job, you will have a better opportunities to work up the files, build them up to the most, and settle them at a higher figure. Of course, some applicants' attorneys might say, oh, Armin, that might make the case complicated because they might join a new employer. Then elect them out. Elect them out. They wouldn't participate in litigation, but your client now has income, stability, not to consider undersettling his case, especially if the, I guess that's the only other thing I would like to add.
Great. Anything for you, Rando?
Yeah, actually, I have a question for Nadia. In terms of injured workers that speak other languages, like, some of my clients are Spanish speakers. What type of, interpreter services do you have through the vocational counseling?
So that's a really great question. I get that asked a lot. Just know that during the work comp case, you're getting reimbursed for the interpreter or the adjuster, or the insurance company is paying for that. Unfortunately, once the case is settled, the voucher doesn't allocate monies for an interpreter. We're very sensitive, and I think every counseling firm or counselor utilized should be sensitive in identifying their team. Example, our team is fluently bilingual, and considering instructors and or particular schools that offer a teacher that speaks in that native language. But it's always important to include a family member if the individual is speaking a language and you don't have somebody that speaks that language, at least for the initial, because then they can be explained what the next step is. And then once that transpires, to identify a program of their interest and see if you can match it up with an instructor or a school that has the staff that can offer that assistance to that individual on that language.
Great, thanks.
How is that?
Awesome, thanks.
All right, good deal. I don't see any more questions that are up on the chat. So with that, this has been recorded. We are going to go ahead and put it up on our YouTube channel. You can also find a ton of other, all of our other webinars and a bunch of interviews on there. The last webinar was on how to use vocational rehabilitation to help your case get 100%. So if you didn't see that one, I believe that one's only audio on there, but if you weren't able to participate, I think that one is worthwhile and does pair very nicely with some of what we've gone over here. So with that, I'm going to go ahead and thank our panelists for joining. Thank everybody for taking your time out to go ahead and join us for this webinar. And for those that were putting in for MCLE credit and gave your bar number, we will be following up once the MCLE credit is approved and get you the information that you need. So with that, thank you, everybody, and have a great rest of your day.
Thank you.
Okay,
Thank you.
thank you, everyone.